As I close, is there a possibility that the applicant will evade trial? I submit that no. Is there a possibility that the applicant will influence the investigation? I submit no. Are the charges against the applicant in this matter serious? I submit no.
If Brown Mogotsi does not get this bail, he has no one else to blame but his legal representation. Because tell me, why is it that his whole legal team is literally downplaying the charges that he's faced with, and also does not see the seriousness of them, seeing the importance of having a verified residential address, especially in light of the charges that Mr. Brown Mogotsi is faced with? In this video, I wanted us to actually look at the two big arguments that were raised by the defense, which are very problematic in my view.
The court would note from the application of the applicant is that he's a well-known businessman and he's a public figure. The applicant has also previously appeared before public institutions, including the Madlanga Commission of Inquiry, and has engaged with parliamentary processes. The applicant is not a person capable of disappearing into anonymity. His identity, movements, and public activities are widely known and readily traceable. The applicant has substantial ties to South Africa, including family, residence, and business interests. The applicant is financially responsible for the support and maintenance of his household and dependents. The applicant further oversees business operations that require his active management and supervision. His continued detention is causing ongoing financial and operational pressures to those businesses, employees, and dependents.
So after Brown Mogotsi appeared at the Madlanga Commission, subsequent to that, later on his way to his home, he was arrested. And the charges were the charges of defeating the ends of justice. This was after he lied and said that there were assassination attempts on his life. But it was later discovered that actually he lied about that. And not just because of the police investigation. Even the residents of the people of Vosloorus also stated that Brown Mogotsi lied and that there was no assassination attempt on his life. Actually, he's the one who shot the particular Chevrolet that he was driving at that particular time.
So to you, did it look like a situation where anybody had been following you?
No.
Following him?
No, there was no one who followed him, because the lady who was next to him when he's busy shooting, even now she's traumatized.
Yeah.
She's traumatized even now, because he was shooting that car facing his direction, for that lady direction.
And that in and of itself is the reason why Mr. Brown Mogotsi is currently in the dock and is fighting for his bail. But now, with this bail application, there's a lot of things that have been raised, that have been argued by the defense, which are very problematic. But before you can understand the case of the defense, it's very important for you to understand what is the state saying. What are the main arguments that the state has raised? The first argument is the one of the alleged bribery. So Brown Mogotsi, there's an allegation that he tried to bribe the investigating officer in this particular case. And the words that were used by the state, they said that he said, "Is there something I can do for you to not oppose the bail?" And that in and of itself is one of the things that they've laid out to say that this man is not the man that should be given a bail, because clearly he has the potential of obstructing the cause of justice or the police investigation, because for him, money is important. Money is something that can be used in regards to this particular case or his case.
If I were about to leave the applicant approach, he made the comment relating to pay. These words were, open quote, "Is there something that I can do for you not to oppose my bail?" Close quote. I immediately took offense, as it was said to me in a context that I understand it to be an attempt to offer a bribe not to oppose his bail, if there would be an opposing application. I told him immediately he must not even think of going that route. He then said to me that it is not what he mail. It is not what he means. He said, the open country. If I would want information from his thought, this comment of him does not make any sense at the time. I told him that there is no information that I need from him related to any other matter.
Then the second thing is the one of the ballistic, is the forensic ballistic contradictions. And that specifically looks at the issue of the red Chevrolet that he was driving on that day. And the main arguments that are raised is that this particular vehicle was stationary and that it was unoccupied, and it looks like someone came and fired at that particular vehicle while it was stationary. And that in and of itself is one of the big arguments that were raised by the state, that Brown Mogotsi actually did not in any way or any form it was a shot at. It looks like the car was parked and then someone came, shot at the car, and there was no one inside from the way it looked. Because the truth be told, guys, for someone that was fired at, for the amount of times Brown Mogotsi said he was fired at, no bruises, nothing, he's unharmed. According to him, he said that, it's luck or whatever the case may be, but it's a big red flag that you are alone in the car. And if you guys can even look at the body of Brown Mogotsi, the way he is, probably I can escape because I'm really small, but for him, he's big. Where did he hide? Where did he go? He just was ducking and diving, and just like that, he survived. I guess we are seeing a live situation of the Matrix. I thought Matrix is something that we just saw in the movies where people are ducking and diving bullets, but here we're seeing a live visual of someone that did a Matrix on the bullets that were fired at his car.
The alleged shots were fired when there's no one, or these shots were not directed at anyone. Now, when we look at the submissions which have been made, there is a particular impression that has been created by the investigating officer that then say that this person is a violent person when the alleged shots were fired when there is no one, or these shots were not directed at anyone.
Then the other issue, which is the big one, part of the issues that I have with this particular case of Brown Mogotsi, is the address verification. So the state says that Brown Mogotsi was not honest with his particular address, and that in a way he's trying to evade trial. And I think today's proceedings were specifically focused on the issue of the wrong address.
And was not traceable on both mentioned cases when looked for. It is a clear indication that there is a likelihood that the applicant could abscond and not stand his trial.
Because the state contends or argues that this person used an address called a number of the house, which was 4454. And the actual one is not 4454, it's 4544. But this 4454 was used more than once. Throughout Brown Mogotsi's papers, he's been using the very same address. The state is saying, how is it possible that this particular person can use the same address and it happens to be an error throughout? It happens to be a mistake that he does over and over again. How many years has this man actually stayed in this particular property? Because if you can't get the address properly, guys, clearly either you are new in that particular property or you have another justification, of which I definitely agree with the state. Because if the address is not properly captured and this person keeps on using the fake address over and over again, then clearly this person is a flight risk, and this person is a person that is capable of evading the trial and not actually being there and attend his entire trial. And not just that, the state also raised the issue of how the IO was looking for him and went to a lot of addresses looking for him but could not find Mr. Mogotsi, despite him being looked for, and he knew that they're looking for him, but they never see it upon himself that he should give a proper and a correct address. He kept on perpetuating the behavior of giving a very wrong address in this particular proceedings. But obviously, his legal representative had a lot to say with regards to this particular issue of the address, which I want to get to before I can complete the arguments that are made by the state.
If the applicant was not residing there and the owner, according to the municipality, did not know that that applicant is there, he would have been out of that place. His assets are there, meaning that between whoever this Albert who signed the lease and the owner, there's knowledge about the applicant living there. We've had instances where people apply to be released on bail who live in informal settlements. You can't even pin a location. But those people are admitted to bail and they're given an opportunity to attend to court outside.
They are saying that Brown Mogotsi is a public figure, he's known, he was testifying at the Madlanga Commission, and that he's a family man and has businesses, and that because of that, there's no way that he's going to evade trial. And then they also spoke about the lease agreement that he's concluded with the landlord, which is Albert Musu Lehoshu or Lehotsu. And he's speaking about this particular person as a landlord to justify the issue of the errors. According to them, remember that the number is an error, it's not the correct number. And he says that it's an honest mistake and that the wife confirmed that the 4544 address is the correct address and that even the lease agreement says that it's 4454, not 4544. And this address, mind you, they're saying that they're in the same area, they're not in different areas, they're in the same particular place. Even though the 4454, they're saying that they found Utandiwe Sonokwan, the person who stays there, and they can find Brown Mogotsi from the investigation of the IO.
And one can argue that it's an honest error.
Which one is correct then?
Your worship will note that the correct one will be the one which is 4544, which was confirmed. 4544, yes, which was confirmed by the wife of the applicant in this matter. And this is according to the investigating officer's statement that when they arrived, she produced the lease agreement, and when we look at the lease agreement, it refers to 4454 and not 4544.
And I'm not going to lie, guys, I was so disappointed in how this issue was downplayed. And them over and over again, stating a case of S versus Lamini, which that case, I don't even think it's S versus Lamini only. There's another case also that was decided by the Constitutional Court, which said that you don't really have to, when you are applying for bail, you don't, and especially, it was especially in light of the people that are staying in informal settlements, where there is no addresses in that particular place, people just stay. And in that particular situation, you don't have to really provide a precise address of where you stay, because of how informal settlements are placed in South Africa. People don't have addresses whenever they stay in informal settlements. That is why they said that as long as someone can just have a particular location. Let me just find the exact words of the Constitutional Court in terms of the principle that we can derive in that particular case. So the right decadenti, it's mostly on the issue of the socio-economic landscape that many individuals live in informal settlements without formal street address or municipal utility bills. The High Court have established that an address does not need to be a wealthy permanent property to be correct. It merely needs to be identifiable. If an accused lives in an informal structure but provides an accurate description or a local point or a contact that allows the IO to physically locate them, that fulfills the legal requirements. Generally, intentionally giving an address where you do not sleep or provide an incorrect location to hide from law enforcement signals and a deliberate attempt to mislead the court. I think that is what is happening. And as I've said, I feel like the defense is downplaying this issue of the address. They're just telling us about jackets, and they're just telling us about how this person is well known at the Madlanga Commission. There's no way that is going to evade trial, but keeps on giving a wrong address over and over again, and it's said to be what? An error.
The confirmation of the chief to say that he is in fact staying at 4454 is also incorrect. Is the chief also making a mistake? Your worship, the submission from the respondent is that there is no mistake. This has been done deliberately.
And I think for me, I hope that the magistrate is actually going to look at this particular judgment that was relied on by the defense, which is the S versus Lamini. Because that states specifically the facts are different from the facts of Brown Mogotsi. Brown Mogotsi definitely, I don't think he stays in an informal settlement. And his property should be identifiable through an address. And them failing to provide that particular address, to me, it signals a flight risk. It signals someone that might evade trial. It signals someone that is not easily accessible. And you cannot use an authority of an informal settlement for someone who probably, is even a man that is a breadwinner, has a business, stays with his wife. These people even said that they concluded a lease agreement. They're fine. They're fine. So I'm so disappointed that the state or the defense actually raised this thing and they made it look like it's a trivial matter that the magistrate can overlook. So yeah, the state simply is arguing that these are two different addresses, and that Brown Mogotsi is lying by saying that these are the same addresses. He's saying that there's two different addresses and that there was never a lease agreement. And if this argument by the state is true, then we are dealing with a probable fraud from the side of Brown Mogotsi together with his wife, of which I think instead of them trying to get him bail, actually they're digging a can full of worms. They just opened this can and a lot of issues are going to be probed, investigated, and probably he might even be faced with further charges.
Its landlord is Albert Moy Sapos. So it is clear that this property, these are two different properties.
Then I also wanted to move to the second issue about the seriousness of this offense. So according to the defense, this case to them, it's not serious. And that is what the arguments that were made by the legal representative of Brown Mogotsi. I want to argue and say that this is very not true. Brown Mogotsi is facing a Schedule 5 offense. A Schedule 5 offense in South Africa is very serious. Hence, you can't get a prosecutor bail with this Schedule 5 offense, or you can't sit in the chambers with judges and get this particular bail. You have to sit and present your case and provide whether it's in the interest of justice for you to be released on bail, and all those factors have to be considered. And with the Brown Mogotsi case, the legal representative coming to tell us that this matter is not as serious, it's very, very problematic. And I think that is another thing that is making them seem as if they just want to throw Brown Mogotsi in jail. And they just want him to stay there up until his trial ends. And if he doesn't get this bail, hopefully he'll do what Nkosi did, try change attorneys and go and appeal in the high courts if he wants to do that, because he has that right.
Schedule 5 deals with the granting of bail prior to the conclusion of your trial. And essentially what it says is that a person who is charged with a Schedule 5 offense must provide evidence that their release on bail will be in the interests of justice.
Basically that they're not a flight risk.
Correct.
The third thing that I want to allude to is the issue of his previous convictions. Previous convictions are very important whenever you're applying for bail. They're literally some of the things that you have to disclose. That is what the law is saying. But with Brown Mogotsi, it did not disclose these 3 charges against him or previous convictions. They are stating that these previous convictions date back to 2 decades ago. A decade, or they said 2 decades ago, but they said it's 2012, that is the previous conviction, and said that it's unrelated and don't establish a particular conduct. That is what the legal representative said. That is why they didn't disclose that particular offense.
The applicant made mention of 2. He made mention of 3 previous convictions. And the state made mention of 5 previous convictions. 6, Your Worship. Your Worship, the submission is that the 3 that were mentioned by the state that the applicant didn't mention, he gave a plausible explanation to the court. And he informed the court that all of them, a fine was imposed and he did not serve any direct imprisonment. Hence, on his limited understanding, that did not make a previous conviction.
But that's the thing. These offenses are related to assault with the intent of causing bodily harm, serious offenses. Like, that's one of them. And one of them, I think, the legal representative of Brown Mogotsi said that he was fined, so he didn't really go to jail. He was not really incarcerated. Therefore, they didn't see the need for them to disclose this. I don't care if whether it happened 70 years ago. If it happened, you have to disclose it. You have to inform the courts that this happened, even though it happened this amount of years ago. The problem is that legal representatives, they mostly rely on pro forma documents. They don't want to draft. You have a pro forma document, you just change the details of your new client and then you submit. You don't want to sit down and properly draft for that particular client. And that is very problematic. Hence, we see such problems of people downplaying serious things. These are legal representatives. They know how important it is that when you deal with a bail application, you have to inform the courts with regards to previous convictions that your client has been charged with. Then, because we deviated guys a little. So the state also spoke about the issue of convictions and that there's 2 assault with intent of causing body harm, and also another one was reckless driving. And we heard even at ad hoc committee how Brown Mogotsi, referred to these things. He said it's personal matters, including the attempted unaliving, which was later withdrawn. He said it's personal stuff. So we left him at that. Mr. I don't want to implicate myself, because now I don't want to implicate myself.
Have you been charged and have cases dropped?
Yes.
How many?
Many times.
Many times. And what were those cases about?
Assault, driving, or not driving, reckless driving, fraud. There are many. I cannot. Perhaps if we had the CP 69 printed,
you will have those.
Yeah.
Is there a murder case that has been dropped on your cases?
Yes, that's correct.
What happened?
It was dropped. The state must.
What happened? Why did they say you murdered somebody?
It happened.
You murdered somebody?
Yes.
Why?
I mean, isn't that personal?
Murder, personal.
No. To say why?
Maybe because to murder.
No. If
Then I want to move to some of the things that defense said in passing, right? We're going to delve deep on them, which is the presumption of innocence, that denying Brown Mogotsi its anticipatory punishment, and that he should be given the bail, and that he did not orchestrate the fake assassination. They're saying that that is false, it is not true, and that he did not evade any arrest or interrogations or investigations, and that his family depends on him and that they rely on him for survival. And then he also spoke about the bribe, saying that with the bribe, it was a misunderstanding between the exchange that he had with the investigating officer, saying that he intended to come to convey a message that they will, that he will fully cooperate and is available if the officer requires any further information from him.
48, the investigating officer mentions this issue of an attempted bribe or whatever. That is neither here or there, because in his own affidavit he also further says that when he asked, the applicant said information. Needless to say that the applicant denies ever offering anything for bribe, because when one looks at a bribe, the applicant would have actually said blatantly, or if there was any intention to bribe, the applicant would have blatantly said, can I give you money so that you can actually give me bail? That is now an attempt to bribe.
So that is what the bail was basically about. I don't know what you guys think about this particular bail of Brown Mogotsi. As I've said in the beginning of this video, I think that if Brown Mogotsi has someone to blame with regards to this particular bail, it's his legal representation, because they've literally downplayed a lot of things. They didn't see the importance of them seeing the seriousness of the charges that Mr. Brown Mogotsi is faced with, and using words such as, it's literally, they were literally saying it's not that deep. That's what they're saying. They're just saying it's really not that deep. It's shallow. It's shallow than what you guys think. I don't know. Let me hear what you think. Let me hear your thoughts. Otherwise, guys, I'll see you on my next upload. Bye.
I'm actually looking at next week. My apology.
As we were just excited. We should have some time.
Next week, Thursday? The 4th.
The 4th is suitable.